One of the most common and costly mistakes I see families make. They think they've sorted everything. Power of attorney in place, bank accounts covered, bills sorted, then something changes. A parent loses mental capacity, a hospital calls, a care decision needs making, and the family discovers something they never expected. They have no legal authority over their parents' care. None. Today I'm going to explain the single most misunderstood thing about lasting power of attorney, why having one type doesn't give you the other, and how families get locked out of decisions at the worst possible moment. There are two separate types of lasting power of attorney: property and financial affairs, and health and welfare. They are completely separate legal documents. Having one does not give you the other. A property and financial affairs LPA lets your attorney manage money, bills, pensions, and property. A health and welfare LPA gives your attorney legal authority over medical treatment, daily care, and crucially, where a person lives. UK government guidance confirms these are two distinct forms: LP1FEF for property and financial affairs, LP1H for health and welfare decisions. If you are applying for both at the same time, you must keep the pages separate. If you mix them up, you may have to make a new LPA and pay the fee again. This is where the confusion starts. Here is a scenario I see more often than you would believe. A son takes out a lasting power of attorney for his father, but only for property and financial affairs. Maybe he didn't know about the health and welfare option. Maybe he assumed one covered everything. The father later loses mental capacity. Now the son has full control over his father's money and property, but he has no legal authority over his father's care. No authority over medical treatment, no authority over where his father lives, no authority over day-to-day care decisions. And because his father has lost capacity, it is now too late to put a health and welfare LPA in place. Once mental capacity is lost, you cannot make a new LPA. The father can no longer consent. So what happens when there is no health and welfare LPA? Decisions fall to something called the best interests process. This is set out in the Mental Capacity Act. Clinicians and local authorities make decisions based on what they believe is in the person's best interests. The family is consulted, but they are not legally in control. Many families are shocked to discover this. Without a health and welfare LPA, families have no automatic legal right to decide whether care should take place at home or in a residential setting. Hospitals or local authorities can make best interest decisions that favour residential care, even when care at home is clinically safe. This is a deeply distressing situation for families. There is another option, but it is not quick and it is not cheap. You can apply to the Court of Protection to become a deputy. This is the only remaining route once capacity is lost and no health and welfare LPA exists. A deputyship can take months to obtain. The process is complicated and expensive. You will need to pay an application fee. And the scope of authority is often more limited than an LPA would have provided. There are two types of deputy: a property and financial affairs deputy, and a personal welfare deputy. You can apply for one or both. But the court must be satisfied that the appointment is necessary, and the process is supervised by the Office of the Public Guardian. A deputy has to submit an annual report on their decisions, income, and expenditure. During the months it takes to get a deputyship, care decisions may already have been made. A quick note on property. In the scenario I described, the father lives with his son. The property is in the son's name. This is one possible variation. But it is not the typical situation. Most families are homeowners or in social housing tenancies, and it is far more common for an adult child to move into a parent's home to provide care, not the other way around. So when I talk about property and care fees, I am talking about the far more common pattern. The parent owns their own home, and the family panics about selling it. This is the part that causes the most worry. Families panic and rush to sell a parent's home to fund care fees. But often, they don't need to, at least not immediately. When someone moves into a care home permanently, there are important safeguards. The 12-week property disregard. For the first 12 weeks in a care home, the value of your home is not included in your financial assessment. This gives families time to think about how they want to pay for care costs. There is also the permanent disregard. If your spouse, civil partner, or a relative aged 60 or over continues to live in the home, the property is disregarded entirely. And there is the deferred payment agreement. This is an arrangement with the local authority that lets you use the value of your home to delay paying care costs. The council pays your care fees on an interim basis and is repaid later, usually from the sale of the home. The purpose of the scheme is simple. People should not be forced to sell their home in their lifetime to pay for their care. What about choosing the care home itself? You have the right to express a preference. Under the Care Act 2014, if you express a preference for particular accommodation, the local authority must meet that preference. Provided certain conditions are met, the accommodation must be suitable to meet the person's needs. It must be available. And if the cost is higher than what the council would normally pay, someone must be willing and able to pay the additional cost. So yes, you have a right to choose, but there are realistic limits. Availability, cost, and whether the home meets assessed needs all factor in. The council must give written reasons if they refuse your preference. One final piece of the puzzle. How do benefits interact with the means test? Attendance allowance is not means tested. Your savings and income do not affect it. But if you are in a local authority-funded care home placement, attendance allowance is typically stopped or reduced. The legislation states that attendance allowance is not payable for any period where a person is a resident in a care home, and any of the costs are borne out of public or local funds. State pension continues. Pension credit may be affected by the means test, so it is essential to understand how all these pieces fit together. The mistake I see most often is this. Families think they have everything sorted. They have a Property and Financial Affairs LPA. They assume that covers everything. But it doesn't. Health and Welfare LPAs are far more likely to be missing, and that absence can have serious consequences. Once mental capacity is lost, it is too late to put a Health and Welfare LPA in place. So my advice is simple. If you are considering lasting power of attorney, make sure you understand both types. Property and Financial Affairs and Health and Welfare. They are separate. They are both important, and you need both. Subscribe to Simply Aging UK for more trusted guidance every week. Take care. I will see you next time.